Many would say that this was historic. An archaic law handed over by our colonial past now stayed. In a big move, the sedition law has been stayed, giving massive relief to all the sedition case accused. As the Supreme Court stayed all cases and proceedings, the Supreme Court ordered to keep all cases in abeyance till review. The Supreme Court stayed the sedition trials till law re-examined. The centre has been asked now to send advisory to states. The Supreme Court has asked the centre states to not file fresh FIRs till this law is reviewed. The centre, in their argument, has said that gravity of pending cases not known. Maybe there is a terror angle. Tushar Mehta, appearing for centre, argued the pending cases are before judicial forum and we need to trust the courts.
We have made our position very clear, and we also informed the Honourable Court about the intention of the Honourable Prime Minister. Beyond that, if anything else have happened, I don't know. We respect the court, we respect the independence of the court, but there are things which is called Lakshman Rekha. All the organs of the state must respect each other. Whatever we say, whatever we do, we have to ensure that we respect the provisions of the Constitution of India as well as all the existing laws.
It's obviously a positive development because this follows Narendra Modi ji's government having filed an affidavit before the Honorable Supreme Court specifically saying that it wishes to examine or re-examine the issue around the sedition law. The government's approach is to make things easier for the citizen and better for the citizen of India. And the Honorable Supreme Court has accepted this point of view. We should wait for what the final analysis comes or the decision comes from the government. And obviously the Honorable Supreme Court will then take a final view on it.
I think this is a historic order of the Supreme Court. The interim order of the Supreme Court is not only right, it is in accord with the sensitivities of the nation at this point of time. I think pursuant to the affidavit filed by the central government and its request for time to re-examine the law, this order was the only right order to have been made, since the fact of the blatant and brazen abuse of the colonial era law is a reality. The only way forward would have been to stay the operation and the implementation of this law till such time as the government completes the review process.
जन विरोधी नीतियों की आलोचना पर जनता को जेल की सलाखों के पीछे डालने वाले शासक जान लें कि अब जनता उठ चुकी है। जनता की आवाज को ना कुचला जा सकता, ना उसका दम घोटा जा सकता, ना उसे दबाया जा सकता, क्योंकि राष्ट्र धर्म में सरकारों की आलोचना और शासकों को सच का आईना दिखाना हमारा धर्म है।
All those accused would be therefore amenable for an immediate release on at least interim bail. That is what I understand. Till this 124 is resolved and the government comes back, whether they are taking it out of the statute book or not.
देश में जब फ्रीडम होने के बाद भी आज एक लोक प्रतिनिधि हो या आम जनता हो या आम पब्लिक कोई भी हो इस देश में रहने वाला, अगर वो अपने धर्म का प्रचार प्रसार करता है, तो आज महाराष्ट्र में ये परिस्थिति निर्माण हुई है कि उनके ऊपर देशद्रोह 124A सेडिशन जैसा कलम लगता है।
उस सभी भारतवासियों को इस सर्वोच्च अदालत की इस वर्डिक्ट का स्वागत करना चाहिए। मैं स्वागत करता हूं और पर्सनली भी मुझे उस बात का विशेष आनंद है कि मेरे दो दोस्त हार्दिक पटेल और कन्हैया कुमार को भी इसमें कुछ रिलीफ मिलेगी। जो भी पॉलिटिकल प्रिजनर्स हैं उन सभी को रिलीफ मिलेगी और मैं मानता हूं कि केंद्र की सरकार को, सारे राज्यों की सरकार को, सबको एक साथ मिलकर एक राष्ट्र के तौर पे हम लोगों को ये डिसाइड करना चाहिए कलेक्टिवली कि अब इस मुल्क में सेडिशन के कानून की कोई जरूरत नहीं है।
ये होल्ड पे रखना एक मुझे लगता है कि सुप्रीम कोर्ट ने अच्छा किया है, क्योंकि उन्होंने सेंटर ने एफिडेविट दिया था कि वो इसको रिविजिट करना चाहते हैं, तो सेंटर को अपॉर्चुनिटी मिल जाएगी कि वो बिल्कुल ओपन माइंड से इसको रिविजिट कर सकें।
Strong criticism on the provisions of Section 124A, that is the sedition law, that it has been misused and misapplied by either by the state government or by the central government. And in fact, the central government indirectly has suggested that they would like to bring certain changes in the said provision of law so that misuse can be avoided. And one change which the central government has suggested, that the prior permission of the Superintendent of Police is necessary for invoking the provisions of sedition, that is 124A.
The court has effectively put the law in abeyance. As far as it has also requested both the center and the states and asked the center to give an advisory to the states that please don't have any fresh cases lodged under this section while the section itself is under review. As far as cases already lodged are concerned, if there are people in custody, it has said that they can approach the appropriate court for bail, and those bail applications will be heard reasonably expeditiously. So the effect of the court stay is to keep the law on hold till Parliament takes an appropriate decision and a review of the matter.